Our next case is People v. Posey. This is a 15-minute mini oral argument on the application. Just a minute. Wait for Mr. Hoffman. Okay. Welcome, and you may reserve some of your time. We ask you to keep track of that on your own, and you have 2 minutes of a free fire zone. You can proceed when you're ready.
Thank you, Chief Justice Clement. Welcome, Justice Kyra Harris-Bolden. May it please the court. Adrienne Young from the State Appellate Defender Office on behalf of Dametrius Posey. I'll reserve 2 minutes for rebuttal, or at least try very hard to. 24 hours after a high-stress, seconds-long shootout, complainant Mr. Bird thoughtfully considered a six-pack photo array containing a photo of my client, Mr. Posey. Mr. Bird chose someone else. Over 9 months later at trial, Mr. Bird pointed to Mr. Posey at counsel table, identifying him for the first time as the shooter. This represents the most concerning aspects of eyewitness identification. Memories rapidly and continuously decay. Mr. Bird had previously seen Mr. Posey in that six-pack photo array where he chose someone else. And now he had a commitment or anchoring effect to that familiar face. Mr. Bird testified confidently, relaying to the jury on direct and cross the certainty of his identification, despite eyewitness confidence having little correlation to identification accuracy. But with no objection, pretrial motion, or eyewitness identification offered, Mr. Posey did not have the effective assistance of counsel. And this identification was profoundly suggestive, a show up in court in front of a jury. This case presents the opportunity to craft a rule where first in time, in-court identifications of strangers are never permissible. They pose too great a risk of wrongful convictions and unfair trials. But that is not requisite for Mr. Posey to get a new trial. Under the Biggers analysis, the identification should have been excluded, especially once this court modernizes that assessment, as suggested in briefing and by Amicus Innocence Project. While a just outcome renders any sentencing issue here moot, this court should, consistent with Lockridge, complete the process of adopting the Booker remedy by severing MCL 7693410, sentence 1, and adopting reasonableness review for all sentences. Mr. Posey's 22-year minimum sentence, selected from a guidelines range over 21 years wide, is disproportionate to him and his offenses.
Counsel,
I invite any questions from the court.
Can I want to address, I have a couple questions about the ID argument. Why are the protections that are afforded at trial not sufficient? A vigorous defense, a vigorous cross-examination by counsel, jury instructions, why is that insufficient?
So my first response to that is, when Neal v. Biggers and the U.S. Supreme Court created this carve-out in the due process selection, they recognized that generally we do rely on those protections from the Sixth Amendment for a fair trial. But it's the likelihood, and this is from Biggers, it's a likelihood of misidentification which violates a defendant's right to due process. And then as a practical matter, why don't those work here with eyewitness identification? Well, for a lot of the reasons you see here in Mr. Posey's case. In cross-examination and direct examination, witnesses are generally the most confident in their identification at trial, despite it being the farthest distance away from the event that they witnessed, and despite their confidence not being an actual indication of the reliability of their identification, but their confidence being incredibly impactful on a jury, where they hit every indicator of credibility, but aren't necessarily sharing accurate information or information with a solid foundation. So this is the type of error where, and presently in Michigan, our jury instructions don't do anything to protect this particular due process right for defendants. In fact, a lot of times they encourage the very issues we're talking about. For example, they talk about our instructions identify certain factors to consider for witness credibility. And here, Mr. Bird's testimony would hit several of those observational points for the jury to find him credible, despite his identification having absolutely no foundation or reliability.
But counsel, are there times that, assuming we agree with the concept that sometimes these identifications are unreliable based on science or whatever the different arguments are there times that a first time in court identification is reliable, or is it always unreliable?
So that's why I think if this court were to adopt a bright line rule, the bright line rule that makes sense is first in time in court identifications of strangers. There are courts that have adopted, like in Massachusetts, there's a pretrial hearing, and they weight very heavily a prior relationship between victim and the accused. So you're not going to have a situation where you're forcing a husband into a pretrial lineup and wife has to come in or partner has to come in and identify the person. So there are certain factors where a first-in-time in-court identification would be considered reliable.
Okay.
Is this Massachusetts rule by statute, court rule, or is it a constitutional finding by the court?
So in Craythorne, the Massachusetts Supreme Court relied on their common law. They have a rich common law history of a amorphous idea of fairness, and that's what they relied upon in creating that. Now, in terms of how exactly that pretrial procedure is laid out, if they then went on to amend court rules as well, that I'm not entirely sure of. But I will say, Justice Zara, you get at a great point. This is a multifaceted problem. The first problem is Mr. Posey's due process rights weren't protected at his trial. So he needs a new trial, and this court should have a due process rule that's modernized and brought from the 1970s to now. But I do think we should change court rules and jury instructions as well.
On that point, do you take issue with the Supreme Court of the United States decision in the Perry case?
I don't, Your Honor, because the question there was, does a privately arranged identification cause the same due process concerns that we've seen with police-arranged identifications or state-arranged identifications? Here we clearly have a state-arranged identification, not one by a private citizen like they analyzed in Perry.
So I read Perry more as requiring police interference or undue influence by police. Is that an over-reading of Perry?
I think it's an overly narrow reading of the term law enforcement. The Perry opinion uses police and law enforcement interchangeably, and I think our case law is clear that law enforcement includes the prosecution. So this case here is one where Mr. Posey's in-court identification was arranged by the prosecutor rather than the police, but both are law enforcement actors.
Can I ask you like a practicality question, right? Like how does this, is it necessary? Is it ever necessary? Or can to do a first time in-court identification?
My thought is no, but I understand that that's a very drastic rule that is not likely to get 7 votes, and so understanding that, I think there's a narrow version of that. No first in time of strangers.
Of strangers. What if even not, if we were inclined to come off of that and sort of model after some of the other states that do that reliability analysis before allowing ID witness testimony in court. Are we creating, like, do we have to have some hearing now every time to say whether or not this witness is reliable before they can offer testimony?
I think
Is that
that
a
would
practical nightmare?
Well, first, I really don't think that's a practical nightmare. There's a wealth of pretrial hearings that happen before a trial comes to pass to begin with. And I do think that's ideal. If we can prevent these these unnecessarily suggestive and totally unreliable IDs from coming in at all, and the jury hearing them at all, that's going to ensure a fair trial, better than anything else. But to your earlier point, what do we do with the test? I think the New Jersey case, the Henderson case out in New Jersey is helpful with that. And your concurrences and dissents in cases like Johnson and Bearden and Moore are helpful as well, because what we can do with that reliability test is add indicia that are more in keeping with the science and perhaps remove those that are actually contrary to the science, like things like witness confidence is one of the 5 vigorous factors.
Do you see any difference between a police officer who confronts a witness with a suspect in a show-up and a formal court proceeding with judge and jury and court reporter as it occurred here?
I think the latter example, which is present here in Mr. Posey's case, is worse.
Why?
And I think that for a couple reasons. First, it's later in time. We know there's a massive decay of memories, and so even though that show up is extraordinarily suggestive, I don't debate that, and I can't, because the ruling in Sammons was show-ups are unreliable, or show-ups are unduly suggestive, full stop. And so both are show-ups. They're both incredibly suggestive. But one's a bit worse because it's later in time, it's in front of the jury, and it happens with the full weight of the government also pointing to Mr. Posey as their chosen person. So I actually think the latter is worse, despite both being, I think, excludable if we want to protect due process rights of defendants.
You want to get to sentencing?
I would love to. So this court presented a couple different grounds on which we can think about MCL 7693410. And to begin, I think Lockridge really contemplated this exact moment that we're here. Yes, Lockridge specifically addressed 2 and 3, sections 2 and 3, but did leave open the fact that there may be additional work necessary to make the statute completely align with Booker and its progeny. And I think to completely Bookerize and adopt that remedy, we can no longer have the 2-tiered system that Gall cautioned against, where we have a harder review for sentences that are outside the guidelines.
So to Bookerize, can we just rely on Lockridge and Steenhouse, or is there more work we need to do if we were to agree with you?
I think we can rely on Lockridge and Steenhouse, but I think in doing that, Lockridge makes clear that the problem here is a Sixth Amendment one. And so while it's pertinent to, cite the relevant case law, I think what exists here is a Sixth Amendment issue. We have a higher standard of review for outside the guideline sentences, and that has a coercive effect on the sentencing in trial courts, such that the Sixth Amendment problem we thought we remedied in cabining trial courts' discretion, we have not completely remedied.
With regard to your state constitutional right to appeal argument, right, that the no meaningful or any review of an in-guideline sentence contradicts the state constitutional right to appeal. Does People versus Coles preclude us from agreeing with you on that?
No, I think the issue before Coles wasn't one about the Michigan Constitution. And so while there is one sentence of dicta opining on whether it links onto the constitutional right or not, I don't think that dictates the outcome of this case with respect to the Michigan constitutional right to appeal. And what I think is actually most helpful is when we look at pleas in our state. They have a very different appellate process, and that happened by a constitutional amendment. So right now we have the total exclusion of multiple sentences from appeal by statute, and the only other time we've at all contracted the right to appeal that's present in our Constitution was by constitutional amendment. And so I don't think Coles is helpful, but I do think history from around the same time with that proposal on pleas is helpful. And I have a minute and 15 left, so I'm going to save it for rebuttal.
Thank you.
Thank you.
Good afternoon. Tim Boffman, Assistant Prosecuting Attorney, representing Kim Worthy, the Wayne County Prosecutor, and the people of the state of Michigan, the appellees in this matter. I'd like to begin with the sentencing issue, which is the common issue in the several cases here today. And the issue there is whether 769.3410 is unconstitutional. And the finding that a statute is unconstitutional is and is supposed to be of some moment. It should clearly appear before a statute is declared to be unconstitutional. But the statute does not deny all appellate review to a sentence within the guidelines. There are certain predicates that have to be met. Guidelines have to be properly scored. So if you have a guideline sentence, there may be challenges to the scoring, and that frankly happens on a fairly regular basis. Inaccurate information can't be considered by the trial judge, and I would include within inaccurate information impermissible information, but if you want to call that a separate category, that's fine, but a judge couldn't say I'm placing somebody within the guidelines at a certain point because of their race or their gender. That would be excluded. But other than that, if those predicates are met, the sentence is simply lawful. Whether it's at the bottom, the middle, or the top, the sentence is a lawful sentence, and those matters that are relevant to whether the sentence is lawful are subject to appellate review. And as Your Honor pointed out in the Coles decision, when this court set aside 100 years of precedent that said as any sentence within the statutory limits was not subject to review, the court did say, and I quote, "We do not agree that the constitutionally guaranteed appeals of right," so it was talking about the appeals of right guaranteed by the Michigan Constitution, "we do not agree that it mandates review of the trial court's exercise of sentencing discretion in order to comport with due process." So I think that's a holding within Coles, and what remains is an argument that somehow the Michigan Constitution demands that every sentence be subject to appellate review for proportionality, and that's really a bit of a misnomer. Proportionality is the rule of decision for the trial judge in setting the sentence. Abuse of discretion is the appellate standard. The court said in Steenhouse, reviews for reasonableness guided by the principle of proportionality, but Steenhouse specifically talked about proportionality is the rule of decision for the sentencing judge. We the appellate court, review for abuse of discretion. Put another way, the defendant is demanding that every sentence must be subject to proportionality review under Milborn for that sentence to be constitutional, or at least for an abuse of discretion. Well, that eradicates the cruel or unusual punishment provision in the Michigan Constitution. If every sentence has to be proportionate, then review for gross proportionality is subsumed. It disappears. You don't need to reach that if you're going to set aside a sentence simply because it was disproportionate. And I think we have to remember that Milborn is not a constitutional case. Milborn modified Coles and changed the appellate standard of review from shocks to conscience to review for proportionality, abuse of discretion / proportionality, because it teased that standard out of the legislative statutory scheme in the criminal code. It says we have a gradation of crimes, we have a gradation of penalties, and therefore we believe, Justice Brickley wrote for the court, that the legislature intended us to review for the proportionality of sentences. So that's not a constitutional case, and the legislature has determined that sentences within the guidelines, once the predicates are met, should not be further reviewed. This court also said in Coles that it was acting as it did. It was setting aside the 100 years of precedent, establishing sentence review by appellate courts because no constitutional, I'm quoting again, or statutory provision exists which limits the review power of this court or precludes it from passing upon the propriety of sentences imposed by trial courts. Well, there is now. There is a sentence that precludes the court from passing on that propriety other than the predicates, statutory predicates which are met. The statute exists, and if we follow Coles, that should be the end of the matter, other than I suppose it is possible, theoretically, for a sentence within the guidelines range, and here we have one below the midpoint, to be unconstitutional, to be grossly disproportionate, and the court could apply a gross disproportionality standard to a sentence. But other than that, once the guidelines are properly scored, no inaccurate or impermissible information is considered, a sentence at the top, the bottom, or anywhere in between is simply a legal, lawful sentence in our view.
Counsel, I'm wondering if you could address Midland cogeneration versus Naphtali. That's the case where we found that abrogating a right to appeal from an administrative decision violated our constitutional guarantee of a right to appeal. How do we square that?
Well, as I said, the right to appeal has not been abrogated for these sentences. You can appeal those matters which are relevant to the lawfulness of the sentence. You can't appeal matters that are not relevant to the lawfulness of the sentence. If the sentence within the guidelines properly scored, no inaccurate information, no impermissible information, there is nothing else that is relevant to the lawfulness of the sentence. But you can appeal those matters, but it would be like anything else.
If we can't review it, does that sound like it's subject to appeal if we're not able to review it?
We are able to review that which affects the legality of the sentence. I mean, if you took any other principle of law, you wouldn't say a challenge could be raised on a ground that doesn't affect the propriety of whatever it is being challenged. You can only raise challenges that go to whether or not that which is imposed or in existence is lawful or not. What goes to the lawfulness of the sentence here is it, are the guidelines properly scored? Was there inaccurate information? Were there impermissible factors? If you don't find those, you have simply found in appellate review of the sentence that it's lawful, unless the Constitution requires that you review for abuse of discretion the trial judge's determination that the guidelines sentence is proportionate. I think that the real underlying predicate here is that judges will sentence within the guidelines simply to avoid having appellate review of their sentences for proportionality or for abuse of discretion. It's a safe thing to do. The sentence won't come back. And I frankly, I have my differences with some trial judges, but I give them more credit than that. The rule of decision, this court said in Steenhouse, for the sentencing judge is proportionality. I think that's what judges are trying to do. It's not remarkable that the bulk of sentences will come out within the guidelines given the offense variables, the offender variables, all those go into the consideration of the guidelines. It's hardly surprising that most judges in most sentences will be within the guidelines. But what the judges, I think, are trying to do is decide, as Steenhouse has directed them to do, what is the proportionate sentence in this case. And sometimes they do go below. To my surprise, the study showed they go below more than they go above. I thought it would be the other way around. But they do go above, they do go below when they think that's the proportionate thing to do. And frankly, though I've just expressed that I have a fair amount of confidence in trial judges, I think it's also true that if you polled the trial judiciary, there'd be a fair number of judges who don't know 769.3410 exists, because that's for the appellate court. They're trying to impose a proportionate sentence. What happens after that, it gets appealed, and if it comes back, it comes back. That's not why they're giving the sentence they're giving. They're giving the sentence because they're making their best effort to come out with a proportionate sentence, and if they believe that means you go below, then they'll go below. If they believe that means you go above, they'll go above. The bulk of the time, they'll find that the guidelines are satisfactory, the range is satisfactory, and they'll sentence within it. But they're not compelled. The guidelines, the real argument here is the guidelines become mandatory because of this provision. I just think that's just not true at all.
Can I have you focus on the ID
Yes.
argument?
Yes.
And the necessity of a first-time in-court identification. If the witness has never previously identified the defendant, what purpose, what is the truth-seeking value of having the prosecutor ask for a first-time in-court identification?
Well, if the witness is prepared to say, as in this case, that's the person who did this to me, whether it's an assault, a kidnapping, a rape, or whatever, they've never identified before. They may have misidentified in this case, but they're prepared to say, I understand all that, as this witness said on the stand, but that's the person. Then the jury decides whether or not that is reliable or not. In cross-examination, the greatest engine for truth, as Wigmore said, that's been devised, cross-examination goes after that.
I mean, is it necessary? If there's always, why can't you even, I mean, how hard is it to do a six-pack? Isn't that normally what it's done?
The prosecution has the burden of proof beyond a reasonable doubt, and if the witness is prepared to say that's the person, I think that's important for the jury to hear.
Do you agree with the problems that are identified with witness ID? I mean, I think Pam, you know, we have all of these standards that I think even Pam agrees with of like, there's a right way to do this
Yeah,
and there's a right way not
certainly,
to.
and we do have an instruction, which we can argue about whether it's adequate. I think it is, and the jury was given it here, that you should consider failures to identify and misidentifications. The jury, the witness was cross-examined on that and was quite candid. Did you just make a snap decision? No, I studied the pictures. And you picked out the wrong person. Yep, I didn't pick him out, but this is the person. And I think the Iowa Supreme Court had it pretty well when it said if we adopt a rule that first in court identifications are precluded, excluding that testimony would effectively deny justice to some victims, because that testimony may be necessary in a case to get the case to the jury. It may be necessary for a jury to be convinced beyond a reasonable doubt.
But counsel, doesn't it make it makes it quite difficult for cross-examination? It's a little bit like what happens in television, where like people stand at the set, they're on the stand, they say, that's the person. I mean, it adds a certain drama to the proceedings that, you know, can create like a certain difficulty in terms of, you know, being able to counteract that, doesn't it?
Well, it may create a difficulty, but it's not an insurmountable difficulty, and it can be effectively done. And I think the defense counsel did a very effective job here in going through how the prior identification process was taken. It wasn't a joke. It was, you took your time and you went through that. And look at, remember there was another person at the scene, Dwayne Scott. Dwayne Scott picked out Mr. Posey at the photo show. So that
But he
identification
did-
was coming in as
excuse
well.
me, but-
When he got to court, did he look at the person sitting at the table and say, well, he's sitting there, it's got to be him? He didn't identify. So the notion that if he's sitting at the table, you're going to identify, the witnesses are testifying as to their best recollection, and if that recollection is subject to attack, you attack it, and then the jury decides.
Can you identify a situation where, where it's necessary for a first-time in-court identification? Not efficient, not effective, because we know it's effective, as you say. Like, why is it necessary? Or when would it be necessary, meaning that you couldn't get a pre-trial identification?
Well, do you mean that the testimony is necessary, or that it's impossible to have had a proceeding prior to that? I don't know that you could ever say that it's impossible to have a procedure in advance of trial
Isn't that
conducted.
frequently done?
You could conduct one. I think here, if you'll remember at the exam, the witness wasn't asked if he could identify, because I don't think anybody realized, given his misidentification at the photo show, that he could identify. They didn't find that out until later. So there wasn't an identification from him at the exam, so they would need to put it in. I mean, it came up before trial and they put it in. I'm not quite sure.
Well, but if we're looking like in Salmons, right, in a pretrial identification, we're looking, is it suggestive? And arguably, this, you know, there's the show up in Salmons, and then in court you have Salmons on steroids, right, maybe. So is it suggestive? Is it necessary?
Well,
And if it's not necessary, why are we doing it?
let's assume you have a misidentification at a photo, or even a live identification. And then the witness says, so you've had those procedures. And then the witness says, I understand that I didn't pick him out, or I picked out the wrong guy, but that's the guy. I was wrong, but I can tell you that's the person. It's not because they're sitting at the table. That's the guy. The question is, are you going to preclude that? Is that witness's testimony that this is the truth, this is what I saw, is it going to be, as the Iowa Supreme Court said, is their shot at justice for what happened to them to be precluded in this situation, or are we going to lay it before the jury and let the jury decide? And I want to back up
Do we
just a
take into
second and say,
consideration time? So if there was a misidentification at the beginning, and then there was a prelim, and there was an opportunity for a witness to say, that's the individual, and then 2 years go by between that point and a trial, is there no consideration that needs to be given to that period of time?
Well, certainly it is. You said it before the jury. You say, as the defense counsel did here, wouldn't you say that your memory is better, closer in time than it is now? Hasn't it been a passage of time from now? And I think we have to go back to Perry. There is no, short of police misconduct in arranging a suggestive identification that could lead to irreparable misidentification. There is no pretrial screen for liability.
Isn't the key of Perry state action and law enforcement sort of generally, but the application in Perry had to do with a police, an identification to a police officer, and we're talking about
in court.
Right.
And I think if you look at all the federal post-Perry cases, they will say that first in court identifications fall within the rule of Perry. The ordinary course of a trial for a witness takes the stand, gives testimony, including an identification, is within the rule of Perry, not precluded. There is no police misconduct in that situation. And I think we're jumping a hoop here. This is an ineffective assistance of counsel claim. And what the defense is asking for you to do is create a new rule. We ban all first in-court identifications. There is no such rule right now. They want you to create it and ban it. Counsel, to be ineffective, had to be, in the language of Strickland, not so deficient that he wasn't functioning as the counsel for the accused. He doesn't have to be prescient. He doesn't have to anticipate that you're going to create a new rule. He has to cross-examine as he did. And I think if this court's going to consider such a rule, which we would oppose on the merits, it ought to do so in a case where it was raised at the trial court, improperly preserved, and not on an ineffective assistance claim under ordinary standard law of ineffective assistance and plain error. You don't create new rules in those situations, and that's really what the defense is asking the court to do. I thank the court for its time.
Thank you. You have a minute and 14 seconds.
Ms. Young, can I just ask you, I hate it when people take up my reply, but can you address the ineffective assistance of counsel issue? What do we do? I mean, you were saying, this is a new rule. We're modernizing. We would be changing the reliability analysis. How can it be ineffective assistance of counsel for counsel not to have argued that it existed if we were to say it now exists?
So I'll answer that in two parts. First, this is a logical extension of the Biggers line of cases. Even if this court applies Biggers as it exists today and applies it here, this identification of Mr. Posey should have been excluded. But more to the point, Mr. Posey's briefing raises ineffective assistance of counsel for failure to object under the Michigan Rules of Evidence, which obviously were in existence at the time of trial, and because there's no foundation for this, and it's way more and because of the lack of foundation, it's much more prejudicial than probative. Additionally, although it wasn't asked for additional briefing by this court, Mr. Posey raises ineffective assistance of counsel for failure to call an expert to articulate these very difficult and contrary to common understanding issues with eyewitness identification. So the grounds for ineffective assistance of counsel are several. And Mr. Posey meets the prejudice standard under ineffective assistance or under plain error. If this court is to adopt the new rule, Mr. Posey was prejudiced by this identification. You cited repeatedly to Salmon's Justice Kavanaugh, and Salmon's provides that courts have widely acknowledged that juries place disproportionate weight on eyewitness identifications, even if they lack an indicia of responsibility. This swayed the outcome of trial. Mr. Posey deserves a new trial, complete with due process protections.
Is it inconsistent to say that the science of eyewitness identification is so well established now? We use the phrase, probably the most abused phrase in modern history, that we should follow the science, but so that we should change the Biggers factors to reflect them, right? It's so well established, everybody knows it, we all know it. And then you have that alternate appellate argument that we apparently didn't want to listen to about that you need an expert to elucidate these scientific principles. Is it inconsistent to have asserted both of those arguments?
No, I think the existence of decades-long scientific consensus and that there's a contrary understanding in common beliefs and common sense isn't inconsistent. There's this court has case law that explains the importance of expert testimony on
But
things that just aren't
The
part
point
of
is, if
general
the science
understanding.
is so well established, why can't the lawyer do what the lawyers always do and cross-examine based on that information? I mean, it's pretty, first of all, this is right up the, a criminal defendant's attorney's alley, right? Cross-examining based on the witness's ability to observe and, you know, the time that went by. These are all sort of the basic things, right? This is like cross-examination 101, isn't it? And now you have some additional materials out there to strengthen your hand even further. Why isn't that sufficient?
I think the reliance on cross-identification is problematic for the exact reasons present here. So in cross-examination, counsel tried to ask, whether Mr. Byrd was certain about his in-court identification. He said he was.
I know, level of
He
confidence,
explained
but
away.
you've told us that that's, the research is clear. I'm assuming that you're right. I don't know this. I haven't looked up the science myself, but let's assume you're right. Everybody knows that. The lawyer gets to say that. The lawyer gets to bring that out on cross-examination and say, are you, you know, or an argument at least, that studies have shown, right?
Well, the lawyer's questions aren't argument, and the lawyer didn't present any argument about the science behind eyewitness testimony. And his cross-examination, in fact, reflected the exact opposite of scientific consensus. Mr. Byrd was allowed to confidently identify someone almost a year after the incident, someone whose picture he had been exposed to after pretrial publicity and a lineup where he picked someone else. So the cross-examination actually exacerbated the harm because Mr. Byrd testified that he was confident that he picked the wrong person. He explained his different identification to the court by saying, the person I picked in the six-pack photo array I thought was Mr. Posey. Turns out it wasn't Mr. Posey. This is the guy I want. He referred to him by name repeatedly. His confidence, everything that would dictate credibility to the jury was present in Mr. Byrd's testimony in direct and in cross-examination. So actually these elements, when left to defense counsel who clearly hadn't consulted with an expert, judging by his line of questioning, actually exacerbated the harm to Mr. Posey.
All right, thank you, counsel.
Thank you. The case will be submitted.